Uh, Good afternoon. This hearing is called to order. I think I'm supposed to do that. That somehow makes it official. This hearing is called to order. Today is March 7th, 2022. This is the time and place set for the public hearing on the proposed amendment of the Commission's discovery rules. I'm Commissioner Tony O'Donnell, presiding officer at this hearing. With me today is Commissioner Randy Pinocci. Commissioner Fielder is with us virtually, and President of the Commission, Commissioner Jim Brown. Montana law requires the presiding officer at a rulemaking hearing to read the following. Notice of functions of Administrative Rule Review Committee. Administrative Rule Review is a function of interim committees and the Environmental Quality Council, EQC. These interim committees and the EQC have administrative rule review, program evaluation, and monitoring functions for the following executive branch agencies and the entities attached to agencies for administrative purposes. Economic Affairs Interim Committee, which includes Department of Agriculture, Department of Commerce, Department of Labor and Industry, Department of Livestock, Office of the State Auditor and Insurance Commissioner, and Office of Economic Development. The Education and Local Government Interim Committee, overseeing State Board of Education, Board of Public Education, Board of Regents of Higher Education, and the Office of Public Instruction. Children, Families, Health, and Human Services Interim Committee, overseeing Department of Public Health and Human Services. The Law and Justice Interim Committee, overseeing Department of Corrections and Department of Justice. The Energy and Telecommunications Interim Committee, overseeing Department of Public Service Regulation. The Revenue and Transportation Interim Committee, overseeing Department of Revenue and Department of Transportation. The State Administration and Veterans Affairs Interim Committee, overseeing Department of Administration, Department of Military Affairs, and Office of the Secretary of State. The Environmental Quality Council, overseeing Department of Environmental Quality, Department of Fish, Wildlife, and Parks, Department of Natural Resources and Conservation, and the Water Policy Interim Committee, where the primary concern is the quality or quantity of water, Department of Environmental Quality, Department of Fish, Wildlife, and Parks, and the Department of Natural Resources and Conservation. These interim committees and the EQC have the authority to make recommendations to an agency regarding the adoption, amendment, or repeal of a rule, or to request that the agency prepare a statement of the estimated economic impact of a proposal. They may also poll the members of the legislature to determine if a proposed rule is consistent with the intent of the legislature, or during a legislative session, introduce a bill repealing a rule or directing an agency to adopt or amend a rule, or a joint resolution, depending that an agency adopt, amend, or repeal a rule. The interim committees and the EQC welcome comments and invite members of the public to appear before them or to send written statements in order to bring to their attention any difficulties with the existing or proposed rules. Their mailing address is P.O. Box 20176, Helena, Montana 59620-1706. I will now ask Mr. Rogala to discuss the notice of public hearing.
Thank you, Commissioner O'Donnell. The notice of public hearing on the proposed rule changes was published on February 8th, 2022 in the Montana Administrative Register pursuant to MAR notice number 38-5-250. The notice was issued by then Commission President James Brown as required by the Attorney General's model rules. I'm to read you the major provisions of the notice of public hearing. A complete copy of the notice will be included in the official record of this hearing. Paragraph 1 of the notice indicates that the purpose of this hearing is to consider the proposed adoption of new Rule 1 pertaining to the Montana Energy Impact Assistance Financing Act. Paragraph 2 of the notice advised the public that the department will make reasonable accommodations for persons with disabilities so those persons can participate in the rulemaking process. Paragraph 3 sets forth the text and justification of the proposed adoption. Paragraph 4 indicates that interested persons may present their view, data, or arguments either orally or in writing at this hearing or after this hearing to the Commission. Paragraph 5 notes that the MCC is available to represent the interests of the consuming public. Paragraph 6 provides that the commission, a commissioner, and a duly appointed presiding officer may preside over and conduct the hearing. Paragraph 7 describes how interested members of the public can receive notices of commission rulemaking proceedings. Paragraph 8 states the bill sponsor contact provisions of 2-4-302 of the Montana Code annotated apply and have been fulfilled. And paragraph 9 states that the amendment and repeal of the above stated rules will not significantly and directly impact small businesses as set out in 2-4-211 of the Montana Code annotated. Thank you, Commissioner O'Donnell.
Thank you, Mr. Regala. The purpose of this hearing is to receive public comments regarding the proposed rule changes. Following the close of the public comment period, the department will summarize and respond to any comments received. The summarized comments and the department's responses will be published in the Montana Administrative Register as part of the rulemaking process. The order of presentation of testimony is as follows: the statement of proponents in favor of the proposed rule changes, the statements of opponents, and the statements of any other persons wishing to be heard. The chair will call on each presenter individually, as identified in paragraph 1 of the commission's notice. If anyone would like a copy of the notice of proposed rulemaking and does not have one, please contact the commission. Please electronically raise your hand on the Zoom platform if you have any questions. So, is there anyone who wishes to speak as a proponent? Chair recognizes Representative Denise Heyman. Welcome.
Thank you. I guess this is on. I want to thank the commissioners for attending this rulemaking hearing. It has been a goal of mine ever since I passed HB 467 that we would reach this point where rules would be written and there would be a process to go forward with this, I believe, very important bill for the ratepayers in Montana. With that said, I will read my testimony. I appreciate the opportunity to provide comments on the PSC Commission's proposed rule to implement House Bill 467 passed in 2019 legislative session. My purpose in sponsoring the bill was to lower electricity bills for utility customers if a utility closes a power plant before it is fully depreciated. At the December 10th, 2021 work session in which I participated, representatives of Northwestern Energy, Montana Dakota Utility, MEIC, and the commission staff compared draft rule language proposed by Northwestern Energy with language proposed for a securitization rule in Indiana. After extensive discussion about the differences between the two documents, as well as consideration of the existing regulatory structure in Montana, all parties agreed that Northwestern Energy's proposed rule and statutes encompassed all of the elements of the Indiana draft. While Northwestern's language was far more truncated than the Indiana proposal, it was clear to all who participated that it included all of the same requirements. This is very important to me as the bill sponsor because the language in the Indiana draft was far more explicit about what a utility application must contain. It's important to have clarity on Montana's rule for securitization to avoid differing interpretations during the formal proceeding to implement the law. I was pleased to have reached agreement with the utilities at the December 2021 meeting on that information. Data, work papers, and supporting evidence must be included in an application to securitize debt. If a dispute resolution is necessary regarding interpretation of the rule, the commission should look to the Indiana language that was discussed at that meeting to verify requirements. One issue that has arisen since the December meeting is concern over the difference between the statutory reference to base rates and the draft rules reference to rate base. These two similar but distinct terms are similar but distinct terms. My intention with this bill was to require more than what the term race bait entails. I appreciate the red line draft provided by the commission staff on February 28, 2022. The staff's proposed language captures the legislative intent for the application to include information on the utility's revenue requirement as defined to include operating expenses, taxes, depreciation, rate base, and the return on rate base. The impact of securitization on a utility's customers, particularly residential customers and small businesses, has always been my highest priority. The utilities application should provide details on how securitization will impact the various customer classes. Without that information, it would be impossible to know whether securitization is in the public interest, which was the intention of the law. Thank you for the opportunity to comment. I appreciate the PSC's attention to this matter and support the rules with the above referenced amendment. Thank you.
Thank you. Appreciate that.
And should I hand this?
Please, that would be.
Okay.
Yes. Thank you. Any other proponents? And I was remiss in announcing the last speaker. And I think the protocol is to ask each person to state their name for the record. So my apologies, if you would.
Yes, my name is Shannon Heim. I'm the Director of Regulatory Counsel at Northwestern Energy, HEIM. We appreciate the opportunity to come before the commission today. We believe that securitization is a tool in the toolbox, an important tool. And like any tool, it has to be well crafted in order to actually be utilized. So these rules, we believe, also capture the legislation as it exists today. And we also support the red line that was offered by staff. In particular, I do want to comment that these rules are came about from a consensus process that we really appreciate and that we think reflects the best of what the commission does. That when staff brings stakeholders with potentially very different intent and view together in a room to really work things out, to continue a dialogue that is very constructive and respectful, we end up with a product that is really workable and that I think the commission can really be proud of. So your staff is to be highly commended on that. Also on the phone is Clark Hensley, who is our corporate counsel who worked most closely on these rules and did a lot of the drafting work. And so I would just defer to him briefly and see if he has any additional comment on the particular red line offered by staff.
Mr. Hensley?
Yeah, Commissioners, Clark Hensley here for Northwestern Energy. And I'd just like to echo what Shannon said. We appreciate the opportunity to work with all parties involved. And we also support the inclusion of the revenue requirement in lieu of the rate base in 2B and 2K of the proposed rules.
Thank you. Time. Any other proponents?
Mr. Chairman, this is Commissioner Fielder. I see that Mike Green has his hand raised electronically.
I couldn't see that on here. It's a little tiny screen right there. And
I can raise my hand, Mr. Chairman, but I'll defer to those in
I
the
see
room
it now.
first.
Okay, very good. Thank you. Please go ahead.
Whatever works best. It's all good. For once, we all get along. Ann Hedges with the Montana Environmental Information Center. And I just want to say, when we first came forward with this idea in the legislature, it was really nice to work with Northwestern and with MDU to try to reach a point where we could all agree and support the legislation. And we were able to do that. And that's not the case in every state that has tried to put forward legislation on securitization. We are one of the, there really aren't very many states that have it. And so I appreciate the fact that it really was the easiest bill I think I've ever passed, especially considering its length. But I think it speaks to the need for this type of tool in the toolbox to help utilities, to help customers, to make sure that our bills are not more expensive than necessary, and also make sure that we have adequate Public Service Commission oversight. It's really important in this arena to make sure that there is transparency and that the Public Service Commission gets the last say on whether this tool is going to be utilized and how that would occur. So we appreciate the utilities, and honestly, that doesn't come out of my mouth very often. So I think that this is a really important first step. We really worked hard, and it was my fault, I apologize, at the December meeting to work through the differences between the proposed Indiana rules and the rules in this case. And what we came up with was very much that Montana rules and the statute cover all the things that Indiana covered, and they were just using different language, and they were being more explicit, where a lot of what occurs in this arena and is required doesn't need to be spelled out in quite so much detail. So we appreciate everybody suffering through that meeting to try to get to a point where we're all on the same page. It was worth it because it's really nice to be at this spot. That doesn't mean when a utility comes forward with securitization and asks you for something that we won't engage and we won't have some differences of opinion. But I do think what it says is that we're all going to be moving towards the same goal, which is trying to make this type of tool work to the benefit of both utilities and customers. It's a balancing act. I really appreciate the staff recognizing that there's a difference between base rate and rate base. I think the commission staff have proposed a good solution that really does cause more inclusivity on what information is going to be necessary, because I think rate base would have been inadequate. So I think this is a great step in the right direction, and I appreciate your time and your staff's time to try to get this right, as well as the time of the utilities who have been working to help make this work for all of us. So thank you, and I hope you can see fit to adopt it. Thank you.
Thank you, Ms. Hedges. Any other proponents in the room? Sorry, Mike. Any other proponents in the room? Seeing none, Mr. Green, you wish
Thank you,
to
Mr. Chairman.
comment?
Can you hear me?
Yes, indeed.
Yeah, I appreciate the opportunity, and I would just echo the comments made by those coming before me today. And I would also just reinforce that I do a lot of administrative agency work in rulemaking, and some agencies have expressed hesitation in the past about engaging in the kind of informal stakeholder input sessions that occurred in this case. And I think this was an opportunity where we had stakeholders on both sides of the kind of substantive issue, as well as the sponsor and staff from the relevant agency come together to put together a package that is much better for you. And then you as the commission still have the opportunity to go through this process and have kind of general members of the public comment on that. And this is a process I would certainly, for your agency, I would encourage you to continue. I think this is, I would disagree with Ms. Hedges' comment to the extent that there was any suffering in that meeting. I thought that was one of the more productive meetings I've engaged in, actually, in my role as counsel for Montana Dakota. And it was nice. It would have been suffering if we'd all had to try to do that process through written comments submitted to you at this stage of the process. So I would encourage you to overcome any hesitation that you might have about allowing those informal give and takes on the front end of a rulemaking process, because I think this did turn out to be a much better and streamlined process than we might have had if either side had just launched its own kind of proposed rules and asked staff to adopt those. adopt those here, or your staff had tried to come up with a compromise set of rules based on kind of the competing interests. Getting us all in a room was incredibly worthwhile exercise, and I appreciate everyone's engagement in that. And going all the way back to the legislature, I would echo Ms. Hedges' comments. I think this was a really a good process. It shows what we can do together if we're able to sit in a room and open our minds and listen more than we talk. And I think this was a really helpful process, and appreciation for Representative Heyman starting the process and then seeing it through to the rulemaking. I've been doing this a long time, and it's not often that we see bill sponsors come in and support rules like Representative Heyman took the time to do today. So I think this was just an incredibly collaborative process from start to finish, and Montana Dakota appreciates that. We would also, for the record, Mr. Chairman, formally request that the commission consider adopting the amendment proposed by your commission staff last week to correct that term of rate base, which was inserted in the draft, to that revenue requirement language, and more filling out kind of the expectation that the utility will have to demonstrate the full financial effects of securitization on its revenue requirements and rate making, rather than just the impacts on the rate base, which is a small, as you all know, a small subset of that. So with that, Mr. Chairman, I'm happy to answer any questions that you have, and would just repeat our appreciation for Northwestern Energy's efforts in taking a shot at drafting rules and getting us started, and everyone else's role in getting us to where we are today.
Thank you, Mr. Green. Any other proponents in the room or online? Any other proponents? Are there any opponents in the room? Any opponents? Any opponents online? No opponents online? Okay. Is there anyone else who wishes to speak on this matter? Oh, sir.
Good afternoon, Mr. Chairman, Commissioners. Good to see you all. I don't wish to appear as a proponent or opponent to the rules.
For the record, would you
For the
identify
record,
yourself?
Thank you, Mr. Chairman. Jason Brown, spelled Brown, and I'm the Consumer Counsel. As I'm sure you all know, our office exists to represent ratepayer interests, mostly before you all. And like I said, I don't wish to appear as a proponent or opponent today. Perhaps I missed it or there was an oversight, but I don't think we were a party to the discussions, any of the discussions referenced or meetings that you heard about. Listening to Mr. Green, I'm kind of sorry I missed it, frankly. Sounds like it was quite the kumbaya session. And we did not take a position on the bill at the legislature, but I think we would certainly expect to participate in any proceedings or applications that were filed to securitize anything by a utility. So I do just have, though, perhaps that helps explain why I have maybe three kind of relatively minor, or four suggestions total, 3 additions and 1 subtraction. First, on the first page, new rule 1 sub 2B, it might be helpful to add a calculation in addition to a description of the applicable infrastructure and the contribution, et cetera. I think a calculation of the contribution to rate base would be helpful in addition to a description there. Number 2, appreciate the commission adding some minimum filing requirements to what's in the statute. I would suggest perhaps after the ones that are there, a bill impact analysis is pretty standard in a lot of filings. You see it a lot with trackers and such things as its own standalone minimum filing requirement. And then I think I would agree with what's been said about addressing kind of the impact on revenue requirement generally, but I don't think I would replace sub K. I think I would keep the rate base piece so the commission can really see what the impact on rate base is going to be, because that's going to be important. That's what the utility, of course, earns a return on. So I would keep that, but then add another minimum filing requirement that addresses the general impact on revenue requirements or revenue requirements impact analysis. And then finally, a subtraction, I would suggest removing L because that section 69.3, 1623 assumes that there's been a transfer of the asset. And I'm not sure the commission necessarily needs to assume that in the minimum filing requirements for an application to create the asset in the first place. And if that does happen, there is some process addressed in the statute for that. So I'm not sure these minimum filing requirements need to assume that that would happen. And that would require a subsequent application in any case. So that's all I have. Thanks again for your time. Good to see you all.
Thank you, Mr. Brown. Anyone else wishes to be heard on this matter? Right. I once again remind everyone that the commission must receive written comments no later than March 14th of this year. Seeing that nobody wishes to offer any further comments at this time, I hereby close this public hearing regarding the commission's rulemaking notice 38-5-250. But also a little, I don't know, the commission's closed, but I have something else to read here. So I take it, put the person who wrote the script on here. Pursuant to state law, the commission must provide an opportunity to the public to comment on any matter within commission jurisdiction. I note there are no commenters on any other matters within the commission's jurisdiction. This meeting is adjourned. Thank you. Do I have to do this?